Hello, I'm attorney Brian Williams, and today I will discuss removal proceedings and some of the relief available to help a person who is in removal proceedings. A removal proceeding is when the U.S. government begins the legal process to deport or remove a non-citizen who is in the United States. It's the U.S. government challenging that person's immigration status and right to remain in the USA. The process used to be done through deportation and exclusion proceedings, but in 1997 the law changed to replace them with removal proceedings. The proceedings are similar, with the differences being the forms of relief available, burden of proof, and custody issues. A naturalized U.S. citizen who is accused of obtaining their citizenship fraudulently can also be placed in removal proceedings, although that process is rare. Removal proceedings begin when the U.S. Immigration and Customs Enforcement, ICE, issues a document called a Notice to Appear. This is the government's charging document and will state that a person, referred to as the respondent, is deportable and will explain the reasons why. There will be a numbered list of accusations that explain why the respondent is deportable. These accusations need to be reviewed carefully to ensure that they are accurate and that the government does in fact have the legal basis to deport the respondent. The notice to appear may include the date and location for the initial hearing, but sometimes that information is provided to the respondent later. It's essential for the respondent to appear at every hearing scheduled in removal proceedings. If the respondent does not appear, the judge will order them removed in absentia, which means without presence. We can discuss the implications of an in absentia order of removal in another video. The first hearing in removal proceedings is called the master calendar hearing. This hearing allows the respondent to respond to the allegations in the notice to appear and to advise the court of any applications for relief that they intend to file. This is done through a process called pleadings. The judge will schedule the individual hearing and set deadlines for filing applications or other documents that will be necessary in the case at the master calendar. Immigration courts are moving towards internet-based hearings, and if the respondent has an attorney, the master calendar hearing is likely to be held online. Some judges are requiring attorneys to file written pleadings instead of holding the master calendar hearing. This allows the court to save a lot of time that can be devoted to individual hearings. The individual hearing, which is sometimes referred to as the merits hearing, is where the respondent has the opportunity to make the case for why he or she should not be deported. Any applications should have already been filed and ready for review before the individual hearing. The respondent and the ICE attorney will present evidence and provide testimony similar to a trial in state court. After the individual hearing, the judge will make a decision and enter an order. Relief from removal are various legal options that a respondent can use to avoid deportation. They are essentially the legal defenses that can help a respondent who is facing removal. The first defense is to challenge the accusations contained in the notice to appear. If the allegations are not correct, the respondent may not actually be deportable. There may be factual inaccuracies, or there may be an incorrect legal conclusion. For example, the notice to appear may claim that there is a conviction that makes the respondent deportable. It may be possible that there is no conviction, or it may be a conviction of a crime that does not make the respondent deportable. This legal analysis is essential. If the notice to appear alleges that the respondent is deportable due to criminal convictions, it may be appropriate to try to have those convictions vacated in criminal court. Next, it's a good idea to consider termination of proceedings. There may be circumstances where it's not in the government's best interest to deport. This oftentimes occurs when a respondent is deportable, but is clearly eligible to fix their immigration situation through USCIS. I've been able to convince ICE attorneys to agree to terminate or dismiss cases where we can show that the respondent is fairly innocent and that the continuing removal proceedings would be a waste of their time. Adjustment of status is the process of applying for permanent residence while in the USA. It's commonly done through USCIS, but can also be obtained as relief from removal proceedings. It requires an approved petition, and then an application for adjustment of status is filed in court. The immigration judge does not have jurisdiction over petitions, so they must be processed by USCIS before the judge can consider the adjustment of status application. If there is an immigrant visa immediately available, meaning either an immediate relative petition or a current priority date, the judge will continue the removal case to give USCIS the opportunity to adjudicate the petition. Once the petition is granted by USCIS, the respondent can file their application to adjust status with the court. In order to be eligible for adjustment of status, the respondent must have been inspected or paroled by U.S. immigration officers before they enter the USA. If the respondent is inadmissible for any reason, they must request and be granted a waiver of inadmissibility. If the judge grants adjustment of status, the respondent is now a permanent resident and their removal case is over. Asylum applications can also be used to defend against removal proceedings. Asylum is an immigration status for someone who cannot return to their home country because they fear persecution due to their race, religion, nationality, political opinion, or membership in a particular social group. Asylum applications must be filed within 1 year of entering the United States, with limited exceptions. A person cannot receive asylum if they persecuted others, pose a security threat to the U.S., or have committed certain serious crimes. If the judge grants asylum, the respondent is granted asylum status that allows them to work and to live in the USA, but does not immediately provide legal permanent residence. A person with asylum status may apply for residence through adjustment of status 1 year after receiving asylum. Cancellation of removal for permanent residence is a form of discretionary relief that allows the judge to cancel the removal of a resident. If the application is granted, the respondent maintains resident status and the grounds of inadmissibility or deportability are waived. In order to obtain cancellation of removal for residence, the respondent must prove that they have been a legal permanent resident for at least 5 years, that they have been continuously residing in the U.S. for at least 7 years, after being admitted in any status, that they did not have any aggravated felony convictions, and that they warrant a favorable exercise of discretion. A respondent who does not have permanent residence but has lived in the U.S. may be eligible for cancellation of removal for non-permanent residents. This cancellation of removal requires a respondent have at least 10 years of continuous physical presence in the U.S., have had good moral character during that period, does not have convictions of removable offenses, and can prove their removal would cause exceptional and unusual hardship to a spouse, parent, or child who is a U.S. citizen or resident. A grant of non-resident cancellation of removal will eventually lead to permanent residence. Violence Against Women's Act, or VAWA, cancellation of removal stops the removal of a resident who has suffered abuse by a spouse or parent. The respondent must prove that they have been battered by or suffered extreme cruelty from their U.S. citizen or resident spouse, former spouse, parent, or are the parent or of a child who has suffered abuse, that they have been continuously present in the U.S. for 3 years, and that they would suffer extreme hardship if they were removed, that they were a person of good moral character, that they did not have certain criminal convictions, and that they warrant a favorable exercise of discretion. Although the name is violence against women, it's available to men as well. If the respondent is deportable and there is no relief from removal available, it may be best to request voluntary departure. Voluntary departure is leaving the U.S. without the judge entering an order of removal. An order of removal bars a respondent from returning to the USA for 5 or 10 years. Voluntary departure can avoid any period of inadmissibility as long as the respondent has not been in the U.S. unlawfully for more than 1 year. Unfortunately, voluntary departure does not avoid the 10 years of inadmissibility that accompanies unlawful presence exceeding 1 year. Requests for voluntary departure can be made at the beginning of removal proceedings or at the conclusion of removal proceedings. To request voluntary departure at the start of proceedings, it must be made before or at the master calendar hearing, request no other forms of relief, admit the respondent is removable, waive all appeal rights, and prove that the respondent has not been convicted of an aggravated felony and is not deportable for national security or public safety reasons. The grant of voluntary departure is discretionary, and the judges usually review the respondent's criminal history before granting voluntary departure. While an aggravated felony statutorily excludes a respondent from voluntary departure, any criminal history can potentially cause the judge to deny the request. The requirements for voluntary departure increase if the request is made at the conclusion of removal proceedings. The respondent would have to prove that they have been physically present in the U.S. for at least 1 year prior to service of the notice to appear, that they have the financial means to post bond within 5 days, and the funds to leave at no expense of the government, that they have been a person of good moral character for at least 5 years, that they have not been convicted of an aggravated felony or as a terrorist, and that they have not been previously granted voluntary departure. If you're facing removal proceedings anywhere in the United States, please contact me at 301-891-8485 or visit my website at www.brianwilliamslaw.com.